The next topic is concluding statements, arguments, and post-hearing briefs, direction of election, and decision to follow. We have Mr. Kirschner, Ms. Sensor, Mr. Deakins, and Mr. King. Once again, thank you all. Mr. Kirschner, can you proceed?
Thank you. Good afternoon, Chairman Pierce and members of the board. Again, my name is Kurt Kirschner. I'm Jones Day, and I'm here on behalf of the AHA ASHRA. The topics for this panel, as you just described, including statements, post-hearing briefs, direction of elections, overlap in some fundamental respects with the topics from the prior panel. If under the board's proposed rules, the hearing would be concluded, then obviously the post-hearing briefs and other matters related to the post-hearing process would be of limited utility. As a result, we believe it's important to underscore the AHA's strongly held view that the NPRM's proposed blanket 20% rule, regardless of the size of the unit or the issues in dispute, would violate Section 9C and would deny due process to the non-petitioning party, leaving scores of unresolved issues, especially supervisory status, as the parties are directed to an election, imposes unfair and unrealistic burdens on hearing officers, will create confusion among voters, and increases both the likelihood of inadvertent unfair labor practices and disputes in the workplace during an election campaign. These effects are especially problematic for employers in the healthcare field, who must promote a tranquil, healing patient care environment at all times. Turning to the board's specific proposals regarding the post-hearing process, the proposed elimination of post-hearing briefs as a matter of right will, in our view, erode the fairness of the hearing process by limiting the parties' ability to articulate their positions and explain applicable authority. Under the proposed amendments, at the close of the hearing, parties will be permitted to file briefs only with the permission of the hearing officer and within the time permitted by and subject to the limitations imposed by the hearing officer, especially in conjunction with the proposed changes to expedite the hearing process. The parties will not know the facts at issue until the hearings occur. Particularly in the healthcare field, with larger units and complex issues regarding supervisory status and other unit determination issues, parties should have the opportunity to brief in writing the legal authority regarding issues raised and facts introduced at the hearing. For example, the role of charge nurses may vary between units in a hospital. The role of charge nurses with respect to whether they're supervisor may vary based on what shift they work with the number of other supervisors around. These issues will depend on the facts that are introduced at the hearing and should require and should allow briefing. The current timeline for submitting briefs is already extremely expedited relative to other litigation standards, generally only a week or two, and in our experience does not unduly delay the representation process. The elimination as a matter of right to file a post-hearing brief is also inconsistent with the limited role of hearing officers allowed under 9C1 of the Act. The NPRM bestows substantial authority to the hearing officers to make myriad determinations, including whether and regarding what issues post-hearing briefing is allowed. In combination, those restrictions grant substantial, we believe, excessive authority to hearing officers and thus would be inconsistent with Section 9C1. Under the current rules, as has been stated before, hearings occur in only a small percentage of the cases. Over 90% of cases result in a stipulation, meaning that no representation hearing and thus no briefing is ever required. In light of how infrequently hearings currently occur under the existing procedures, the AHA does not believe that any of the proposed changes that are at issue in this panel's topics need to occur. If a party does not believe that a post-hearing brief is necessary, then that party is free to offer an oral argument in conclusion at the hearing. But that should not preclude the other parties, however, from briefing the issues that were raised during the hearing if that party feels doing so would be helpful to clarifying and presenting the arguments. In response to one of the issues posed by the board, we do not believe that a direction of election should precede a decision. The direction of election obviously couldn't be issued until the basis of the decision has already been determined. Issuing a direction of election while the board sits on the decision, would keep the parties in the dark regarding the board's rationale for its determination. This could lead to questions and even suspicions regarding the basis of the conclusions that are embodied in the direction of election. Not issuing decisions until sometime before the election itself leaves the parties uninformed about the basis of the potential appeal to the board, which of course implicates another set of proposed rule changes. Based on our experience, issuing the direction of election prior to decision would not likely save more than a brief period of time in the vast majority of cases, especially given the direction of elections could not be prepared until the basis of decision has already been made. I'll see that I'm out of time, so I'll conclude there. Thank you.
You say that the filing of a post-hearing brief is a matter of right. What's your basis for saying that?
My understanding is that under the current rules, hearing officers routinely grant the party the right to file a post-hearing brief.
Okay, and you know, I practiced before the board, and I was a hearing officer, and I was 15 years in a regional office, and it's my understanding that that is a discretion and imparted by the regional director. Well, though commonly granted, it's not clear to me that that is a right, and if I'm incorrect, I'd like some correction in that regard. But that being said, if it is the regional director's call with respect to the determinations that are the legal determinations that are made based on the facts as laid out by in the hearing, and isn't it the current job of the hearing officer not to make a legal determination but to facilitate the development of the record?
That's correct, and that's what's required by the Act. Our concern is that by having the hearing officer be able to make determinations about what the scope of the hearing should be, applying the summary judgment rule with respect to whether there's sufficient evidence to support an issue, enabling the hearing officer to determine whether and under what conditions and about what briefing could be done. In combination, all of those items together give such substantial authority to the hearing officer that we believe, in effect, that the hearing officer is essentially making a recommendation which is precluded by 9C1.
Okay. Questions?
Except one. As you indicated, commonly the parties are allowed 7 days to file briefs. And so that 7-day period sort of ends up going by whether the parties file briefs or not, right?
Goes by, meaning prior to a direction of election.
Right.
Well, I would think that it depends on the circumstances. I would think that the board typically would want to receive the brief before issuing the direction of election.
Right, but that's what I'm saying. But there's no obligation on the parties to file briefs, and often the DDE waits the 7 days, or at least the 7 days, even if no briefs are received.
That is my understanding as well. I think that the issue here is whether the parties should have an ability following the hearing to take the time to brief certain legal issues that remain in contention. I mean, as indicated, most of representation hearings get stipulated to, and so it may be that by the conclusion of the hearing that there aren't any live issues, and you could reach the stipulation at that point. But I agree with Member Schiffer that there is typically that 7-day period, regardless whether the parties are filing briefs or not.
Would you have a problem then with basically having a declaration of whether to file briefs that would then affect the timetable?
I would think it'd be helpful for the board to know whether the parties intend to file briefs, because parties, if they were taking the time to file a brief, would hope that someone would be reading it and considering it before making the decision. And so therefore, having a declaration about whether briefs will be filed or not would, I think, be rewarding to the parties to know that someone is actually going to read it, and helpful to the board to know whether they should be waiting for it or not.
Okay, what if somebody said, well, you know, Mr. Kirschner, why wouldn't pre-hearing briefs serve the same purpose as post-hearing briefs?
Particularly given the timetable for representation hearings, a pre-hearing brief would be problematic because the parties don't yet know what the true issues are going to be. It's not until you go through the hearing and you know whether there are certain issues, for example, whether someone's in one bargaining unit or another, whether someone's a supervisor or not. You don't know until you've completed the hearing what the true final issues are going to be. And it may be that that through the course of the hearing you resolve a lot of issues that you thought were going to be open issues at the commencement of the hearing. So you only need to brief you know, a couple of narrow issues. They might still be very important, but I would think post-hearing briefing would provide much more utility than pre-hearing briefing, given the lack of discovery and the timeline between the petition and the hearing.
What issues might be too thorny to argue in other than oral argument form?
I think some of the supervisory status issues are particularly complicated. It's a fact-based test, and you may have individuals who might have the same title but who perform different functions. So going back to the example I mentioned before, you could have charge nurses who are on the floor on a unit during the day shift, and they may have their manager and director around at the same time. Conversely, a same charge nurse in terms of title could be on a night shift and no other managers are around, thereby effectively giving that nurse far more leeway with respect to management and supervision of the nurses who were on the floor at that point. So sometimes those very specific situations require briefing, citation to the record, and application of a complex and fact-based test that the board has articulated for supervisory status.
What's the prevalence of documentary evidence in the healthcare industry in these kind of cases?
Well, all hospitals do need to comply with Joint Commission and other obligations to have written position descriptions. So hospitals generally have position descriptions, but in my experience, those position descriptions may not be fully descriptive of the duties that the employees fulfill relative to the tasks applied by the board. So you write the position description not to determine whether they're a supervisor or in a technical or service bargaining unit. You write the position description for the purposes of running your hospital. And therefore, the key elements of supervisory status, for example, may not be fully reflected in that job description.
I may not be remembering correctly, but did you tell us most hearings you've been involved with lasted a day?
That was not me.
Okay. I believe there have been comments that most hearings have, the time is about a day. But my question to you was if there was an opportunity to have a brief break to sort of collect thoughts, would that make a difference in the having an oral argument at the conclusion of the hearing?
In my experience, and perhaps it is me, if I were orally arguing a case and I haven't had the time to reflect fully on all of the facts and evidence that has come in, I am going to try to make sure that I argue and touch on each and every issue that could potentially be raised.
I'm like that too.
If you have some time to review the transcript and focus on your arguments, you actually may, in writing, brief fewer issues, but I think also more effectively.
Okay. That actually was not my experience at the regional level, but I see the logic.
Thank you.
Okay, thank you.